This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305.
All right, I'd like to call the second meeting of the Senate Courts of Justice Committee To order, clerk will open the roll. Attendance.
Mr. Chair, you have a quorum?
Excellent. We got a quorum. First up on the docket, we have Senator D-Steph. D-Steph, I think you've got, do you have two bills?
Yes, sir, Mr. Chairman.
Okay, we're going to roll one into, we already talked about one of your bills. We'll just wait for Stuart to present that later. So Senator Deeds moves, Senator Boysko seconds that Senate Bill 946 be rolled into Senate Bill 926. And with Senator Stewart to be the primary patron, D-Stuff will be listed as a chief incorporated patron, whatever that word is. You good with that?
Mr. Chairman, I'm good with that, and we just want to make sure that we have the line amendment on that one, and I'll make sure you got the perfect.
Okay.
We're good.
Okay, clerk will open the roll for that motion. Okay,
Ayes 11, no zero.
one second. And the other thing, before you go, Senator D-Steph, I just want to say that Senator Diggs has asked that we strike Senate Bill 1027, and Senator Mokai has asked that we strike Senate Bill 1205. So Senator Deeds moves, and Boysko seconds that we strike Senate Bills 1027, 1205 in a block. Is that okay? Huh?
Individual. I don't have a block function.
Got it. No block function. Okay. Deeds moves, Boysko seconds that we strike Senate Bill 1027. Clerk open the roll.
Ayes 11, no zero.
Okay, Senator Deeds moves, Boysko seconds that we strike Senate Bill 1205. Mokais, open the roll, please. Okay, now, Senator,
Ayes 11, no zero.
oh, sorry, MJ, thank you. All right. So, D-Step, that leaves you with, what? 952, fleeing from a law enforcement officer. My recollection is we saw maybe a version of this last year, is that right?
Mr. Chairman, I believe we had a version of this. I'm not sure if it was last year or the year before.
Mr. Chairman, you had one last year, but I think the patron withdrew it.
Yes, sir, I believe that was correct, because we didn't have the language right. And, Mr. Chairman, we actually have a substitute for this that
Okay.
reads a little bit
All
better.
right, Deeds moves, Boysko seconds that we adopt substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay, substitutes before us. Members, you have it here on a piece of paper. Problem with this is the world can't see it. We can't publish it to the internet like this.
It's simply.
Mr. Chairman, it truly is grammatical and flow.
Okay, why don't you
it's
tell us
a-
what's different about your sub than what's online?
Mr. Chairman, it's truly grammatical and flow, the difference between what's online and the sub. And let me explain the concept of the bill and what's in here. And it basically clarifies that the distance requirement being 10 yards or 30 feet. And what we've done in the amendment, we say any person who knowingly and intentionally prevents or attempts to prevent a law enforcement officer from lawfully arresting them with or without a warrant is guilty of Class 1 misdemeanor. And for purposes of the subsection, prevents or attempts to prevent an arrest means fleeing from a law enforcement officer when such officer has legal authority to place a person under arrest for an offense for which he would receive a jail or prison sentence. The officer has communicated clearly to the person that he's under arrest. The person knows or has reason to know that the officer is in fact a law enforcement officer as defined in subsection G of 18257, and the officer has applied physical force to the person or is within 30 feet, 10 yards of the person when he communicates to that person that he's under arrest. Mr. Chairman, that's exactly the substitute, almost word for word.
Okay. All right, Senator. So you didn't present this last time, right?
No, sir, we didn't prevent this last time, Mr. Chairman, and the reason we didn't present it was because it just frankly wasn't ready for prime time. And we wanted to work on it. We wanted to put some time and effort into it to make sure that it was ready and we could defend it and move forward smartly.
Okay. Does anybody have any questions for Senator Distaff? No question? Yeah, Senator Peak.
Was there a particular, question to the patron, was there a particular incident that occurred a year or two ago that led you to bring this bill?
Mr. Chairman, as a matter of fact, there was, and I could give you the case.
The case, Mr. Chairman, is Hackett versus Commonwealth. It's a 2023 case. In that case, the person that the officer was trying to arrest was about 25 yards away when the officer said, "You're under arrest." In response, the suspect turned and ran. He was charged with fleeing or trying to prevent an arrest, and the Court of Appeals, interpreting current law, said you have to be within, the officer either has to have applied physical force to you, or you must be able to immediately do so. And the court ruled that a distance of 20 or 25 yards did not permit an immediate effectation of an arrest.
Hey, Senator Peak, you got another?
Mr. Chairman, Senator Peak, if I may, that is in fact the case, and we believe that 30 feet or 10 yards is very reasonable to cover very, very quickly. If you don't believe me, we can ask Senator Rouse, who can tell you 10 yards, you can get somebody very quickly.
Senator Deeds.
But if I understand,
Oh, there you
if
go.
I understood what's Steve's explanation, that guy would have been, 25 yards, so 75 feet, clearly out of this bill. If a guy is within 10 yards, wouldn't he already be subject to arrest under the court's opinion?
Mr. Chairman, Senator Deeds, the Court of Appeals would say no. Because immediate ability to effect an arrest means you're actually within the immediate span of control. And the court took very seriously and interpreted strictly the wording of the statute.
Okay.
Okay. Any other questions for Senator Distaff?
Mr. Chair.
Senator Boysko.
Thank you. Mr. Chair, I feel like we've had a bill similar to this, and I just want to make
I
certain.
thought so too.
So if a group of teenagers happen to be around, in a park, and they're afraid when the police says something to them, and then they flee, that they hadn't been doing anything wrong, would that not, would they then be incarcerated just because they flee, because you're putting on a new penalty just for running away in fear?
Mr. Chairman, if I may. Mr. Chairman, Senator
Yeah,
Boysko.
go ahead.
No, actually, it says clearly in here that the officer has the legal authority to place a person under arrest and has communicated to the person, and the person knows or has reason to know that the law enforcement officer is an officer, and in fact, that they're guilty and knows that they would go to jail or prison. So you have all of those qualifiers. So a group of teenagers in a park, one would have to be within 10 yards or 30 feet from the officer, which is pretty close. I mean, 30 feet's not that far. Two, they would have to be guilty of a Class 1 misdemeanor for the purpose of this subsection, prevents or attempts to prevent an arrest, meaning that they're fleeing from a law enforcement officer when the officer has that legal authority, but the scenario in which you gave, Senator Boysko, this would not apply at all, and they would not get arrested if they didn't do anything wrong, and chances are they're probably further away than 10 yards or 30 feet.
So, I don't know whether Joanne or Steve wants to handle this, but with the new language that Senator Distaff's adding to the statute, where it says, where such officer has the legal authority to place the person under arrest for the offense. To me, correct me if I'm wrong, but that doesn't mean the person has to be guilty. It just
does
means there
not.
has to be probable cause to place them under arrest, which could be somebody who's completely innocent, and maybe they're say you have a group of kids sitting around, one of them smoking a joint, the others aren't doing anything. The officer walks up and says, stop, you're all under arrest. They all scatter. now you got 5 misdemeanors instead of 1, right?
Mr. Chairman, if I may, that's a civil offense. So this specifically says an offense for which you may receive a jail or prison
All right, Senator,
sentence.
but hold on. How about we change it to a can of beer?
Or
And
trespass.
underage, or trespassing. Trespassing on a park, class 1 misdemeanor. Underage, can of beer, one kid has a beer in their hand, or we see this at Jiffy Lube Pavilion all the time, where there'll be people out drinking behind a car before a concert. One of them's drinking, the other ones are just around. You could, right, am I
Mr.
reading
Chairman, you are correct. And both you and Senator Boysko have articulated the policy concerns that the committee has historically had, that this would be adding an offense where there already is an offense that has been committed or for which at least there's probable cause. And number two, that there are those who may feel that that the wiser choice is to flee from the police rather than have a police encounter. Those are policy factors that the committee has considered before. Senator Steph wanted to put this bill in the best possible posture and with components that made sense.
Got it. Okay. Any other questions for Senator Dista? No, doesn't look like. Is there anybody, you have anybody in favor?
Oh, there we go. Looks like we got one person in favor.
Any attendees online in favor, please raise your hand now.
Come on up, come on.
Mr. Chair, members of the committee, my name is Dr. Michael Huffman, and I represent the Virginia Assembly of Independent Baptists, and I come before you in support of SB 952. As a brat who was raised in a policeman's home, I understand what it means to uphold the law. We need to have tough laws on those who break them, and I support this bill 100%. Thank you.
Okay, thanks. Anybody online? No? Okay, is anybody opposed to the bill?
Any attendees online in opposition, please raise your hand now.
Mr. Chair, members of the committee, Valerie Slater with Rise for Youth and the Virginia State Conference and AACP, we strongly oppose this bill.
Thanks. Anybody online opposed? Okay, doesn't look like there's anybody online either. Senator, do you have anything you want to say before we wrap this up?
Mr. Chair, members of the committee, thank you for your time. That's all I got.
Okay. All right, bill's before us. Anybody got a motion? It's been moved and seconded. The bill be reported.
Substitute motion.
What is it?
That was quick.
Second.
Okay, it's been moved and seconded. The bill be PBI, and that takes priority. Clerk will open the roll.
Mr. Chair, members of the committee, thank you very much.
Thanks, Senator. Okay.
Ayes 9, noes 5.
All right. Next up, even though she is not on the sign-up list, I know Senator Locke has a quick one, and we heard her bill in full last hearing. We now have an amendment to it. We want to try and knock that out really quick. We have this amendment in the packet.
Yeah, there's the substitute, or just the amendment? Substitute?
A substitute in the packet.
It's on its own.
Oh, it's loose. It's loose. Okay, we have a loose sub. Did we adopt a sub last time? No subs or amendments last time? Okay. Deeds moves, Boysko seconds. We adopt substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay, so we have a substitute before us. It looks like the change on it is, let's see,
Mr. Chairman, the change is
239. Yeah.
on line 239.
Yeah, and basically we've added to it that if this child, who gets a CHINS petition, if they can show that the safety of the child's family or the public is at risk, the child can be taken into custody. That was the change we talked about in committee last time. Yeah, Counsel, you have something you want to say?
Mr. Chair, Senator Locke, this one is from the committee.
Right.
Yeah. Okay. Okay. Any questions about the substitute? We heard this in full last committee meeting. Doesn't sound like it. Senator Locke, anything else you want to say? You're good with the sub, right? Mm-hmm. Yep. Okay.
Report the substitute.
This does not go to finance, right? Okay, it's been moved, and Deeds moves, Boysko seconds, the bill be reported. Clerk will open the roll.
Ayes 11, noes 3.
Okay, bill reports 11-3. Did I hear somebody say Locke has a second? I didn't think so. That's it, right? Okay, next up, I've got Reeves.
Thank you, Mr. Chairman, members of the committee. I have before you Senate Bill 861 at the request of my Commonwealth Attorney in Orange County, Mr. Higginbotham. It's kind of a little technical cleanup bill on a definition of what police officer is. Basically, what happened was Commonwealth Attorney they had somebody locked up who tried to escape from the sheriff deputy with attempting to disarm the law enforcement officer and he wanted to charge 18-478, which specifically uses the term police officer, and this is a sheriff deputy in a municipality where there are no police officers. So this bill would clean it up to make both 18-478 and 18-479, which already uses the broader term law enforcement officer. It would clarify that, striking police, inserting law enforcement officer, and defined in both those code sections for 18-2-57.
Okay. Senator Deeds.
Senator Reeves, has there been a real problem where somebody's escaped from a law enforcement officer and not received the proper punishment, or is this just an academic exercise?
Mr. Chairman, Senator Deeds, I think my Commonwealth Attorney was trying to make sure that in other jurisdictions such as ours that have just sheriffs as law enforcement, that we clean the code up as well. When he went to find this happened, he couldn't charge that code section. So I think it's probably good prudence to clean it up. And my Commonwealth Attorney is here if you'd like to speak to him, I think. Is he?
Sure. Bring one up. Was it
Higginbotham.
Higginbotham. Spatsy?
Orange.
Oh, Orange.
Commonwealth Attorney Paige Higginbotham. Nice to see you.
Welcome to the committee.
Thank you, sir. I also have with me Chief Assistant Commonwealth Attorney Crystal Hastings. It's actually her case to answer Senator Deeds' question that brought this to our attention. If the committee would like to hear from her, she could explain the circumstances and sort of set forth why we're here and why we think it's important. So I'd like to yield to Ms. Hastings, if that's okay. Thank you.
Sure. Welcome, Ms. Hastings.
Thank you. So the particular charge that we're talking about, there was a deputy sheriff from Fluvanna who was escorting a defendant to Fluvanna for charges. She stopped at a Burger King and was allowing this individual to go to the bathroom. She had unhandcuffed him so he could go to the bathroom. Whenever she went to go link him back up, he grabbed a hold of her hands. He pulled her into the bathroom. He put his arm around her neck. He took her to the ground. He tried to disarm her of her firearm, and he also disarmed her of her taser. He fought with her for probably 2 minutes, but seemed like an eternity to her. And this was an act of violence. He put his feet up against the door where nobody could come in, and she couldn't get out. So the particular charge that I ended up charging did not indicate the violence, but 18-478 shows violence, and I believe that it was a more adequate charge to put the public on notice.
Then your concern basically is you could have charged in that situation with an assault and battery against a law enforcement officer, would have brought a mandatory minimum sentence punishment, and also an abduction, I think. Yeah, and maybe something else, but that's not enough.
So we did charge assault and battery law enforcement, and he was convicted of that. But we also believe that there was more than that because he was trying to escape and the means by which he did so. The violence that he inflicted upon the officer, and we thought that that needed to be indicated in the charge. And whenever you read a criminal history, you need to be able, the law enforcement officer who responds to this person later needs to be able to see that on a criminal record.
Okay. Mr. Chair, I'm just trying to figure that we've already made the policy decision, this ought to be the law. You're just trying to make it apply to the people that are actually doing the work.
Yes, Your Honor.
Okay.
Your Honor. Okay. Any other questions for Senator Reeves about this? I got a question for counsel. I don't know whether Steve or Joanna wants to handle this, but does anybody know why we have two different definitions of law enforcement officer between 57 and 9.1101?
Mr. Chairman, no, we don't know why we have two different definitions. And that might be a good task for someone to take up, is unifying
Criminal
the
Justice
definition.
Conference or something?
Yes.
Yeah, all right. Okay. Any other questions? Senator Reeves? You've already got
Mr. Chairman,
anything else in support? Hold on.
No, sir. I
Anybody
just
else
think
in
it's
support?
problematic in those jurisdictions.
Okay, hold on. Is anybody else in support? Anybody online in support? Okay, anybody opposed? Anybody opposed online? Okay. Anything else you want to say, Senator?
No, sir.
Oh, you opposed? Okay, come on up.
I'm with Rise for Youth, and we strongly oppose this bill.
Do you have, is there a reason or no? Okay. All right. Okay, bill's before us. Anybody got a motion? Okay, Obscene moves, Stewart seconds, bill be reported. Clerk will open the
It has
roll.
to go to finance.
Oh, does it? Okay, sorry. I guess they moved,
Moved report.
report be referred to finance. Okay, clerk will open the roll.
Senator Stewart for Senator McDougal.
Stewie.
Senator Stewart for Senator McDougal.
Oh, I'm sorry. Bill Stanley keeps bothering me.
Ayes 15, no zero.
Thank you, Mr. Chairman. Members.
I know where mine is. We talked about it. All right, next up I've got Williams Graves. I said I know where Ryan is. Yeah. We talked about it.
Good afternoon.
Good afternoon, Senator. You've got you've got beaten up school ref.
Yes. Senate Bill 986. So, Senate Bill 986, the assault and battery of sports official, making it a Class 1 misdemeanor for a person to commit an assault or assault and battery against another, knowing or have reason to know that such individual is a sports official defined in the bill for an entity sponsoring an interscholastic or intercollegiate sports event, or any person performing services as a sports official for the public entity or for a private nonprofit organization that sponsors an amateur event who is engaged in the performance of his duties. The bill requires such person, upon conviction, to be prohibited from attending any sports events operated by the entity or organization that employed such sports official for a period of not less than 6 months as a term or condition of the sentence. This bill amends Code 18.2-57 of the Virginia Code to include enhanced penalties for assault and battery committed against sports officials while performing their duties. So there are a couple of things to note here. We're making this a Class 1 misdemeanor. Conviction includes a mandatory prohibition from attending events operated.
Senator, yeah, let me try and shorten this a bit.
Okay.
So here's our question. And the work group who looked at your bill had similar questions.
Okay.
So it's already a crime to assault and batter a person, right? And so it's already a Class 1 misdemeanor, just like your bill. So the question we had is, why do we have to create a whole separate subsection to do that? It seems to me what your objective is, and correct me if I'm wrong, is if the person who is assaulted happens to be one of these sports officials, you want to make sure that the person is prohibited from attending any sporting events operated by the entity or organization for not less than 6 months.
Right.
As a condition of the sentence. That's basically what you want.
Yes.
Okay. So it seems to me that we need to strike lines 59 through 63 through Class 1 misdemeanor, and we need to modify that sentence to say, if the person is a sports official, then the sentence should be as follows, something like that. That's really what you're after.
Yes.
Mr. Chair, if the person assaults, if the person assaulted is if the person who commits the assault against another, knowing or having reason to know that the individual is a sports official for an entity sponsoring an interscholastic or intercollegiate sport event, or any person performing services as a sports official for a public entity or a private nonprofit organization that sponsors an amateur sporting event that is engaged in the duties engaged in the performance of his duties, then that person who commits that assault would be prohibited from attending a sporting event if they're found guilty for 6 months.
Counsel, you get that? Okay. Work on it for a second there. Williams-Graves, that's basically what you want,
That
right?
is basically what we're asking,
Okay,
yes.
so why don't we take this by for a second, counsel, and you go clean up the words. Go with Williams-Graves over in the corner, clean up the words. We'll bring you right back and put it in front of us, and then we'll deal with it that way. Okay?
Because he's mimicking the same language, so keep it the way he said, knowing or having a reason to know.
You just sit there and suck it up.
Like the fumble that was called.
Keep it knowing,
Yeah.
yeah.
Okay.
Knowing or having reason
So Williams-Graves,
to
why don't you
know,
go off
just
with
like they have.
Ms. Fry and figure out okay, go up and do that, and we'll come back. Okay, next up, I got Sturdivant. Sturdivant's outside, okay, he missed his chance. New Craig.
Okay, thank you, Mr.
New
Chairman.
Craig, you've got, what, one?
Yes, 846.
846.
There is a substitute.
You got a sub?
Yes.
All right, subs in the packet. All right, Deeds moves, Boyce goes seconds, that, the substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay, subs before us. Senator New Craig, why don't you tell us what you're doing here?
So basically, this bill is relating to the access to minors' records stored or accessible through a secure website. Right now, parents can get their records through in person. This is just allowing, if there is a secured website available for medical or school records, that they are allowed to access them. All the other...
This has to do with the statute in the child custody section of the code, which talks about what records parents can access.
Right.
And
And we haven't changed any of that.
Is there some ambiguity about whether or not parents can access records on a website versus records that are in paper?
I'll yield to the attorney, because we just did the substitute before I went into session.
Yes, Mr. Chair. So I don't know exactly the background, obviously, of the bill, and I'm not sure I could comment on that, but the language does clarify that where a parent is allowed access or can't be denied access to academic health records or other school records,
Okay, so.
that the secure website counts as well.
Okay, so I amended this statute about 4 years ago because there was daycare centers that didn't think that daycare centers were included in health or educational records. Was there a situation that happened that caused you to bring this bill?
I just had a constituent that said they had issues and they wouldn't allow them, they had to come in person. And so they have a secure website. We thought we'd put this in code that if they do have a secure website and they're able to access that they can do that.
All right, legislating by anecdote, but I don't think it does a lot of harm. Anybody have any questions for the patron? Nope. Anybody in favor? Family Law Coalition, you around? They're the ones that see this lot. Gary, have you looked at this? You guys good?
Mr. Chairman, we haven't looked at it. I don't think it's something that we have an issue with.
Okay, I don't think so either.
I had to hear the companion bill in the House.
Okay, got it. Okay, anybody opposed? In favor or opposed?
Any attendees online in favor, please raise your hand now.
They want to snatch victory from the jaws, or defeat from the jaws. They're in favor, okay, we don't need to hear from them.
Move to report.
Okay, Open Shane moves, aired seconds, the bill be reported. Clerk will open the roll.
Ayes 15, no zero.
Thank you. Y'all have a wonderful day.
Yeah, Sturdivant's back. Yeah, Sturdivant, Mr. Chance, now you're up. You're the last one in the queue.
Thank you.
You got a med mal bill or about med mal certifications?
Yes, Senate Bill 892 there's a substitute.
Okay, Deeds moves, Boyce seconds. We adopt the substitute. All those in favor say aye. Aye. Anybody opposed? No. What number? 892.
892, this is, I
Why don't
think
you tell us
mostly,
what it does?
mostly now a cleanup bill that has the Peace in the Valley among VTLA and Medical Society and the Hospital Association. As you know, for a med-mal case, as the plaintiff, when you request service of process, you are certifying that you have had the case reviewed by a qualified expert who says that there has been a breach of the standard of care and that the breach caused the plaintiff's injuries. What this bill does is essentially sets out in black and white terms exactly what that expert certification has to say. And then the one other change that came about through negotiations is under current law, the plaintiff does not have to provide that certification to defense counsel until defense counsel requests it. And then you have 10 days to provide a response that certifying that you have had the expert review. What the bill does now is, as the plaintiff, when you receive the defendant's answer, within 21 days, you'll have to affirmatively send that certification.
Okay, and did you think about the idea we talked about on the floor today about what happens if you forget after 21 days to certify? What's the...
Yeah, I talked about that with VTLA. I think the penalty for not compliance, as the way the law is written now, it remains the same under this substitute. In other words, if a defendant asks you to certify and you don't do it within 10 days, there's the whole host of remedies that the defense can ask for, including motion to dismiss. But as the plaintiff, you still have your non-suit by right. And so the same will apply should
we have today?
Pardon me?
Same that we have today, but instead of 10 days, you got 21?
Correct.
Okay. All right. Any questions to the patron? Yeah. Senator Obenshain?
Did I understand you to say that upon request, you have to produce the actual letter certifying?
No, that...
Okay. I thought glad I misunderstood.
No. Any other questions to the patron? No. Is there anybody opposed to the bill?
Any attendees online opposed to the bill, please raise your hand now.
Doesn't look like there's any opposition.
I move
Okay.
the report.
It's been moved and seconded. The bill will be reported by Deeds and Obenshain. Clerk will open the roll.
Ayes 15, no zero.
15-0, you're reported. That's it, right?
I've got two others.
Oh, you do? Oh, wow, okay, hold on. What do you want to do next?
I've got 1115. Yeah.
Oh, I see that now. Okay, 1115. Action for damages, legal malpractice during estate planning. Oh, yeah, this one's kind of a tricky one. Okay. Why don't you explain what this is about?
So in 2016, there was a Virginia Supreme Court opinion that essentially created a new cause of action for attorney malpractice, where a third-party beneficiary of a will would be allowed to sue the attorney drafter of the will instrument. And then in 2017, we attempted to revise that to clarify that, in fact, there is no cause of action by a third-party beneficiary in a testamentary case. Boyd Graves got together and identified that perhaps the way the law as drafted and revised in 2017 perhaps doesn't cover the waterfront in that area. And so this bill attempts to make that clearer, that in fact an attorney does not owe a legal duty to any person other than the client for whom they are engaged to prepare the will. And that way it's, I think, making it clearer that someone who is a beneficiary of that will cannot come in 25 years later and sue for alleged legal malpractice.
Okay, so basically, you don't think this changes the law, it just makes it clearer, and that's what Boyd Graves thought too?
Mr. Chairman, yes, it's declarative of existing law, but clearer.
Okay. Anybody have any questions for Senator Sturdivant about this bill to make things clear?
Any
Senator
attendees
Obenshain has-
online that would like to speak, please raise your hand.
Senator Obenshain, our resident trust and estates litigator, has questions.
All I was going to say is, I mean, I think what this expands, arguably expands from existing law, or maybe clarifies as to existing laws, that the representation agreement can expressly state that the beneficiaries are intended third-party beneficiaries, so that they're not foreclosed in the unlikely event that such a expansive representation agreement is entered. So, and that's the significant difference that I saw.
Mr.
Or
Chair,
clarification.
yeah, Mr. Chairman, Senator Obenshain, it does specifically state here that the retainer agreement can allow for extending a duty to a third-party beneficiary. That's true.
Right. Okay. Any other questions for Senator Sturdivant? I assume Boyd Graves in favor. Is there anybody else in favor besides Boyd Graves? Is there anybody opposed to the bill? Okay, it's been moved and seconded. The bill be reported. Clerk will open the roll.
Ayes 15, no zero.
Bill reports. Senator Sturdivant, you're here on a roll today.
One final bill, sir. 1116.
More Boyd Graves, huh?
It's a VBA.
Oh. We don't agree with them, Boyd.
Yeah.
Okay. 116, Uniform Trust Code. What are we doing here?
Presently, for a spendthrift trust, which I had to look up, but that's a trust where the creator of the trust is also a beneficiary. We define, well, Senator Obenshain can correct me if I'm wrong on that, but regardless, we're talking about a specifically in the context of a spendthrift trust. Who are the qualified trustees to be able to operate as trustees of that trust? Under current law, it appears to prevent law firms and charities and other similar organizations from serving as a trustee of a spendthrift trust. And so what this bill does is clarifies the definition of an independent qualified trustee and of a qualified trustee with the practical effect that law firms, lawyers, charities would be able to serve as trustees of a spendthrift trust.
So, Senator, is there any difference between the people that are currently, the only ones that are currently I don't care about the person so much, but it talks about, right now, current law is a legal entity authorized to engage in the trust business. You want to change it to a legal entity authorized by law to act as a trustee. Is there any difference in like the bonding requirements or the professional certifications or anything else between those two kinds of people? Looks like Obenshain might have an answer.
The bond, my understanding, and Eric's over here, but my understanding is that the bond requirement would essentially be established in the trust document as to, whether bond is required, whether surety is required on the bond, or whether it's waived. But I guess, this changes, as I see it, this changes the definition of who's a qualified trustee. It doesn't have to be someone authorized to engage in trust business, but it's somebody who is authorized by law to act as a trustee. It just broadens who can serve. Is that right?
Yeah. Yes.
Well, right. Well, that's how I saw it. Clearly, somebody wants some more business. I'm just trying to figure out if those new people that want this business have the same sort of professional qualifications, the same, potential. You can sue them and get money out of them as easily, or what? Whether there's more or worse protections.
Mr. Chairman, part of the problem is that a spendthrift trust is a trust designed to protect the assets of the beneficiary of the trust, keep a child from pledging the benefits under the trust and essentially spending them before he's entitled to. And a lot of these trusts are relatively small, and getting a trust department for a bank to undertake to, administer a trust is very, very difficult. So, as I see it, and again, Barr may correct me, but this expands the definition a little bit in order to, make sure that these trusts can actually be administered.
Okay. Senator Obenshain with the lifeline there for Senator Sturdivant. Anybody else? Any other questions for the senator? Senator Stewart.
I just want to make sure I understand. This is not something I do, but I've actually litigated a case under this provision where a trustee wasn't qualified to do an action. Who is authorized by law to act as a trustee? Can you tell me who would qualify by law to act as a trustee? So if Senator Obenshain is right and we're expanding it, who are those individuals now that could do that?
It's a good question, and I, Mr. Chairman, Senator Stewart, I don't know that off the top of my head.
Link, do you know? VBA know? Trust are us.
Mr. Chairman, members of the committee, Eric Link on behalf of the Virginia Bar Association. My expert witness was unable to make it today, so you're stuck with me, and I apologize. This change recognizes that many trustees do so. Many lawyers are trustees through their firms. The change, they're trustees, but they want to do it through their firm for continuity reasons. The change does not alter anything substantively. No tax or practical reason not to allow firms or charities to serve as a trustee of these trusts when they can serve as other kind of trustees of other trusts already. And I apologize for fumbling through that. Was that responsive to your question?
I think so. I think what you said is that they're allowed to serve as trustees for everything but a spendthrift trust, and they want to be able to get spendthrift trust also.
The chair said it better than me.
Well, Mr. Chairman, I still
Okay, Senator Stewart.
I still want to know who's allowed to act as a trustee by law. That's
Probably
my
anybody
issue.
that the court says.
Maybe Mr. Benjamin can help me. I don't understand. It's not defined in the bill. Maybe it references something else, but let me tell you something. These provisions have real-world consequences when trustees take acts and then you go back and sue later, so we need to make sure we get it right.
You're saying you want to go by for the day and get an expert in here to answer our questions? So that goes right to the heart of the bill.
I don't understand who can do it as a result of the
Okay,
change.
Senator Obenshain, you have an answer?
64.2-1403 sets forth the qualifications of a trustee and defines who is permitted to serve as a trust and who isn't. And basically, it's anybody who, if they're required to qualify before the circuit court or give a bond, anybody that the court approves, or if it does not require the trustee to qualify, it says that it is any person requested by, I guess, the maker of the document.
Mr. Chairman?
Yeah, Senator Stewart.
So, I can't get my mic to work. So, then why wouldn't we reference that provision to say any law authorized under the law pursuant to section 64 point whatever?
Because it's in the same title.
Okay. If you're comfortable with it.
He does this stuff. Questions. He does this stuff.
Okay, it sounds like we're slowly getting comfortable with it. No other questions? We ready to vote? You guys ready to vote down there? Everybody ready to vote down there? Okay, is there a motion?
Move to report.
It's been moved and seconded. Yeah, thirded now, the bill will be reported. Clerk will open the roll. Okay.
Ayes 13, no 0, abstentions
You lulled
2.
us into submission.
What's that?
You lulled us into submission.
Yes.
We're too baffled to kill it.
Thank you.
We need to get somebody on this committee that does trust in the states, like puts them together, not just
You mean
sues.
unlike me?
Yeah, you sue over it. Okay, next up, we got Williams Graves is back. Come on up. We got new language.
Mr. Chairman, we do have new language, but I should have spoken up earlier. I looked at the entire bill, and I see that in subsections D, E, and F, we also say any person who commits an assault or an assault and battery is guilty of a Class 1 misdemeanor. So I think that the original drafting is fine. It just duplicates the way that we do it in the preceding subsections. So it's the will of the committee, Mr. Chairman, whether you want different language or to use the same language we've used before.
It just sounds like really bad habits by us to keep repeating the same thing again and again.
Could be.
Sounds like a statute needs to be cleaned up.
Well, in some of those subsections, they specifically say if you commit a battery and not an assault or an assault and battery. So there may have been reasons for using that language in the past. You'll see that in subsection D, it's only a battery, same with subsection E, but down on F, it's assault or an assault and battery.
I remember when we passed those bills. I didn't like them when we passed them, but I remember them.
Sounds like the cleanup is a whole nother bill.
Yeah, it is. It is.
What she's saying is get your own bill, Mr.
Okay. What do you think we should do?
I just think this should be clear.
Okay. At least some of us up here think we're sort of overthinking this. Can you believe that?
To err on the side of consistency, we could probably just leave it the way that they drafted it.
Right. Okay. Well, now that we got that settled, anybody else have any other questions for Senator Williams Graves? Okay. We have any sports referees here in favor? No? No travel sports, no travel soccer parents opposed? Anybody opposed? Yeah, Senator Jordan. Sure, go for it. Did you make a motion? Okay, it's been moved and seconded by Jordan and Stanley. The bill be reported. Some bipartisan help there for you, Williams Graves. All right, all those, clerk will open the roll.
We're one big team. Smile.
Ayes 15, no zero.
All right, you're done.
Thank you. Have a good day.
Yep. Okay, now we're left with, I think, committee member bills. Those, Stanley, I think you wanted 904 to go by for the day, right?
That's correct.
Okay, Senate Bill 904 will go by for the day. We will hear that
Monday.
Monday, not Friday. Monday. Sabrina, got it? Sabrina, Monday docket? Monday. Yeah.
Monday.
Okay, and then what happened to Head? I know he was going to work on his. I don't see him here. So without Head here, then we have committee members. Who wants to go first? Open Chain, Line of Duty Act. 1142. This bill has to go to Finance, along with deeds as well, if we like it.
Mr. Chairman, members of the committee, this bill you've seen twice before. It has passed the Senate, I think, unanimously on 2 different occasions. There is a substitute.
Deeds moves,
I
Boyce
move.
seconds, we adopt substitute. All those in favor say aye. Aye. Anybody opposed? Nope. Okay.
This bill, as you may recall, basically gives private colleges and universities the option to elect to have their police departments covered by the Line of Duty Act. They would have to bear the entire expense. They are all entering into, or all of those have entered into mutual aid agreements with the localities in which they operate. These police officers are In my case, we had a police officer at Bridgewater College who was shot and killed, too. And these officers routinely aid and assist the Rockingham County Sheriff's Office, the Bridgewater Police. They put themselves in the line of fire every day and face the same risks as sheriff's deputies and police officers. They are not permitted to have their officers participate in the Line of Duty Act. This would require them to pay all of the expense, the premiums, the administrative expense. The colleges and universities have agreed that they're happy to pay the overhead that VRS has indicated that they would have in order to administer this. We also, as a consequence of the shooting death of the Wintergreen police officer, added these private police departments who likewise enter into these mutual aid agreements and are designated as integral components of the local government's public safety system. And
When's the last time we passed this?
Last year.
We passed it, what, unanimous?
Unanimously last year.
Mr. Chair, we passed this twice, I think.
And
Yes.
it has encountered some consternation in House appropriations, we believe over the private components, but I will tell you that in existing law, we've already created coverage for private entities, private fire companies, private volunteer fire companies, volunteer rescue squads. They are required to participate. And in most instances, local government picks up the tab for them. In this instance, we just want them to be allowed to participate, to bear the expense themselves. And so.
And Mr. Chair.
Okay, Senator Deeds.
The way this thing is written, it doesn't apply if the private police force or college does not pay the freight. There's no risk to the taxpayer of the Commonwealth of Virginia. And these officers, very often, they do perform a vital service. Particularly I can speak in Wintergreen, and in that end of Nelson County, there's very little law enforcement, and the Wintergreen cops do an awful lot of work out there in coordination with the local sheriff's department.
Well, sounds like there's not much disagreement about this. We need to send it on its way to see the House Appropriations Committee.
I move that we report and we refer to finance.
Second.
It's been moved, we report and we refer to finance. Any further discussion, anything? No? Okay, clerk, open the roll. Is Carol Floyd, she can fix that when she comes back. We'll get her when she comes back.
I think you got her.
Okay. All right.
Thank you.
That's it, right?
That's it.
Okay, open chain's done. I think, Jordan, you want to go next?
Yes. Yes, that is correct.
Thank you, Mr. Chair, members of the committee. Let me know when you're ready.
Go for it.
All right, before you today, I have
We
Senate
got
Bill.
1095.
Yes, sir. Senate Bill 1095 before you today. This is a cleanup bill that was a recommendation from the Judicial Council. And what this bill will do, it has a cross-reference for foreign protective orders in Code Section 16.1-253.2. Currently, charges may issue for violations of foreign protective orders under the general full faith and credit. This amendment will eliminate any potential for confusion as to whether foreign protective orders may be enforced within the Commonwealth. So it's merely a cleanup bill, if you will.
Okay, hold on. So you want to give a protective order of another state full faith and credit?
This is for what would be considered, quote, foreign
What?
jurisdiction. This would be, quote, foreign jurisdictions, which is other states. It's just clarifying that language. It was a recommendation from Judicial Council, and OES is here if you have any questions.
Mr.
Yeah,
Chair.
I think I wasn't there for that part of the meeting. Yeah.
Mr. Chair, the language tracks the language in 16.1 to 79.1, subsection F, which already gives those protective orders full faith and credit in the Commonwealth.
Okay. I have notes here that say that in order for full faith and credit to apply, there must be, the issuing jurisdiction must have provided reasonable notice and opportunity to be heard to the person against whom the order is sought to be enforced. Where does that get picked up in here?
Yes, Mr. Chair, it's also in subsection F, where they are accorded, where foreign protective orders are accorded full faith and credit. The language about halfway in that subsection says, provided reasonable notice and opportunity to be heard were given by the issuing jurisdiction.
Okay, so that's picked up in 16.1, 279.1F. Yeah?
That's correct.
Okay, all right. Any questions? Senator Jordan, Dees, do you have a question?
I guess my question is, if it's picked up there, why does it need to be picked up here too? If they're judges that can't read the law, why don't we just write the judges letters and say, take a look at this code section that applies?
Good afternoon, Mr. Chairman, members of the committee. Alyssa Patton with the Office of the Executive Secretary. This is more of a belt and suspenders approach due to the concern for victims of domestic violence. Members of our legislative committees and the Judicial Council thought that this cross-reference would be helpful to eliminate any potential for confusion.
Okay, we're doing belts and suspenders for judges that can't read. All right. Anybody else, any questions? No. Anybody support besides OES? No. Anybody opposed? Okay, it's been moved and seconded. The bill be reported. Clerk will open the roll. We're cooking with gas today, man.
Thank you.
Ayes 14, no zeros.
It's like local government. When are we going to start killing things? Oh, McDougal, you're back. You want held in contempt.
It's kind of shocking.
Okay, more committee member bills. Who wants to go next? Perry's first list, but she's not here. Stewart, you want to go? 926. And we got some kind of an amendment D-Steph said on that. Yep, because we rolled D-Steph's bill in.
Mr. Chairman, I think that somebody has a line amendment. If I would move that, if you would report it, please.
Mr. Chair, the line amendment for SB 926 is on line 83, introduced after police, insert appointed pursuant to section 28.2-106. And I will note for the committee that this will need to be turned into a substitute since we rolled in Senator D-Steph's bill.
Okay.
Senator, Deeds moves, Boyce goes seconds. The amendment to make clear exactly which kind of Marine police we're referring to. All those in favor of that amendment, say aye. Aye. Anybody opposed? No. Okay. Senator Stewart, why don't you explain your bill?
Mr. Chairman, this just adds the Virginia Marine Police to the list of those officers that if you assault them, it goes from a Class 1 misdemeanor to a Class 6 felony. Currently, it is any law enforcement officer, correctional officer, firefighter, emergency medical services provider, magistrate, or judge. And I think you all recall some time ago you eliminated the minimum mandatory on these provisions, so there's no minimum mandatory associated with it. It just would heighten the crime. These officers, I will tell you, in my part of the world, have just as tough a job as everybody else. Thank you. I was born her to death. I was born her to death.
I assume the Marine police are in favor. Is anybody opposed to the bill? Yeah. Anybody opposed? Man, where's all the opposition today? Okay.
There's no need to oppose it. It's a good bill.
Okay, it's been a motion by, what was it, aired? Go, Carol Foy. Carol Foy moves and somebody else down there seconded. We report and re-refer the bill to finance. Clerk will open the roll.
Ayes 10, noes 5.
All right, bills off to finance. Welcome back. Does anybody know where Head is? He must have assumed I was taking him by for the day, I guess. Can one of you guys ask Head? Okay, who's next? Okay, 9:31, obscene materials at the library. We'll go by for the day. I don't know when I'll docket that next. Okay. Okay, he's trying to fix it up, I think. So,
95, I can.
yeah, Deeds, why don't you knock out yours?
What,
1195, Land Duty Act.
Senate Bill 1195 simply aligns the time for, under Line of Duty Act with occupational cancer for the same period under workers' compensation. In 2022, we passed legislation expanding coverage for occupational cancer under the Workers' Compensation Act from 5 years to 10 years. We failed at that time to expand coverage for occupational cancer under the Line of Duty Act, which remains at 5 years. We took the action we did in 2017 because of cancer's latency. The same argument would apply under the Line of Duty Act, I think. This bill just simply aligns with workers' compensation law. Jennifer Pike with the professional firefighters is here to talk about it if you like. Occupational cancer is a problem, a significant cause of death.
Move to report.
Wait. We do have to see if there's opposition. I know you guys want to move things along. We do have a process, so. Come on, due process is alive and well in this committee. Okay, is there anybody opposed to the bill? We check if there's anybody online? Nobody online left? Nobody's opposed. Man. Okay. Yeah. Got it. So who made the motion? Carol Foy? Oh, Aird this time.
It's got to go to finance.
Okay, Aird moves the bill will be reported referred to finance, and Carol Foy seconds. Clerk will open the roll. You guys are getting punchy.
Wait till Friday afternoon.
Yeah, tell me about it.
You got Friday afternoon stuff.
Ayes 15, no 0.
Next up is either me, Carol Foy, or Perry, I think, right? Okay, Carol Foy. Yeah, she's outside right there, but yeah.
All right, Mr. Chairman, members of the committee, Senate Bill 965, what it does, it is pretty much codifies what is common practice, and it's clarifying. It basically states that the ability of counsel or parties to record proceedings in juvenile domestic relations court, it has to be authorized by statute. And there is a statute that does that. However, there has been some judges who have read the code that says JDR, I'm sorry. Before I delve deep, I have line amendments. Would council please read?
Yeah, so there's an amendment?
Yes.
There's 3 amendments, Mr. Chair.
Can you read the amendment?
Yep.
I think it's to strike unnecessary language, right?
No, Mr. Chair, it's actually adding a couple things. Number 1 is on line 17, after section, insert or a transcript of such recording. And that same amendment is repeated on lines 18 and 21.
Okay. It's been moved and seconded. We add a transcript in addition to the recording. All those in favor say aye. Aye. Anybody opposed? No. Okay.
And Mr. Chairman, we were also.
Yeah, Counsel, I think you would suggest that we strike lines 20 through 21 as being unnecessary, right?
Yes, that's correct, Mr. Chairman.
Senator Carol Foy, our work group that looked at this thought lines 20 through 21 were completely unnecessary.
That is correct.
Okay, you good with that?
I agree with that.
Okay, so Carol Foy moves and Aird seconds that we strike lines 20 through 21 from the bill. All those in favor say aye. Aye. Anybody opposed? No. Okay, so now we have a bill in front of us. Senator Obenshain.
Does the transcript need to be notarized, or what do you do?
We usually don't make a transcript.
Yes,
We just added or transcript.
Mr. Chair,
Senator Deeds.
when you are in general district court, the defense lawyer is making a recording that's not going to be, it's not under oath, it's not not evidence, it's just, you're primarily doing it to help you prepare for the circuit court proceeding. You're trying to get as much information as you can about what the witnesses say, and it's not under oath.
That is correct. So,
Senator Kilfoy.
yes, thank you, Mr. Chairman. So you have the permission to record. Some judges do not believe because it says general district, because it says district court, that it applies to JDR. So we want to make sure that's clarified. The piece about the transcript is that we don't want onerous or tedious or costly conditions put on counsel's ability to record in courts not of record. Some judges are saying you have to transcribe an entire hearing, or you have to file it with the court, and that is, go ahead.
But my
Senator
point is,
Obscene.
and I understand that it's not under oath, but when a transcript is prepared, who's preparing it? What assurance do you have that it's an accurate transcript? When you have an audio recording, you can listen to it and tell that it's accurate. And I just wonder if you're putting a transcript that some unnamed staff member in your office is typing up and sticking it in the file, how's it going to be used, and what assurance do you have that it's accurate?
You go ahead.
Mr. Chairman.
Hey, Mr. Benjamin.
This is not a transcript that would be introduced into evidence unless there were no objections. If there's a court reporter there who provides a transcript, then by statute, that transcript is admissible. This is simply something attorneys who don't bring a court reporter to general district court make recordings, and sometimes they will make their own transcript for their own purposes of that recording. All this bill does is say a judge can't order an attorney to lodge a copy of his own recording or his own transcript, which is basically work notes, with the file. It doesn't make it admissible.
So the secretary or paralegal typing it doesn't have to certify that it's a true and accurate transcript to the best of my ability to type it?
Mr. Chairman, they don't, because again, this is solely for the attorney's use.
Okay, hold on, Senator Deeds.
Well,
and then Carol Foy, your light's still going? Okay.
I apologize. The only point I was going to make, that it does an additional thing, it ensures that you can make the recording in juvenile and domestic relations district court.
Correct.
That is correct.
Which right now, the rules, I think, the rules of court have something in there about it, I think, but I think the statute's consistent with the rules. I think, my recollection of the juvenile court rules. But anything else you want to say, Carol Foy?
Just want to clarify that it just says that if I, as an attorney, want to record a proceeding, that then the court can't force me to then take my work product and transcribe it and file it with the court. They can't make me submit to them my auto recording that I'm simply using for my records to prepare for any appealable issues or to prepare for impeachment. So that's it. So there's some judges who have taken a different reading of what the current law is, and this is just clarifying.
Mm-hmm.
I think, Mr. Chairman, that the courts may have a concern about the bill. Sorry. Never mind.
I don't have a concern either.
You oppose, support, neither, here for this bill?
I support.
I think the bills are probably in pretty good shape, right? Yeah, Senator Stewart?
I mean, why is this any different than your notes? I don't see where it's any different than the notes that you may take during trial, and the judge ought not be able to force you to put those notes in the file.
Yeah.
It's no different.
Right.
That's right.
Right.
Vote to report.
Okay, it's been moved and seconded. The bill be reported by Aird and Boysko. Clerk will open the roll. Wait, hold on, One on, what?
One question. So,
Speaking to the motion.
I don't disagree if they're used as notes, but what if you do appeal off a misdemeanor case and there's no transcript and you're indicating that certain things occurred? At that juncture, should there be the ability
Senator,
to put that in?
this statute doesn't affect the admissibility of the transcript in a future proceeding. This just has to do with whether a judge can order you to go manufacture a transcript to put in a general district court file because the judge doesn't like you recording in their courtroom.
Give them a copy of it to put in the best file.
This doesn't have to do
So,
with what you're talking about.
If you appeal, this won't have a, judge could order it then? If you do a, where you, I'm asking the question of if you appeal to the Court of Appeals or Supreme Court.
No, this has, Section B has to do with judges of district courts.
Okay.
This just says the general district court judge can't order you to go make a transcript of what you have on your phone.
It's not circuit court.
Okay, it's been moved and reported, the bill be reported. Clerk will open the roll.
Deeds, yeah, there you go. All right. Ayes 15, no zero.
Okay, bill reports. Perry, you're up. Crack and Coke.
All right, this is Senate Bill 888. This is a bill that eliminates the sentencing disparities that still exist in the criminal code between crack and powder cocaine. It just makes an amendment to Section 182248, which deals with the distribution of those substances. These differences occur down at the bottom of Section A. Whenever you're talking about the heavier weights, there is a disparity between what you're punished for as it relates to crack versus what you're punished for related to cocaine, even though they have, even if they are of the same weights. And this just fixes that disparity. I don't know if VACA is here or not, but I do know they can speak for themselves, but I believe they're in support of the bill.
Okay, so this eliminates sentencing disparities between crack and powder cocaine, which they've done at the federal level years ago. VACA, you guys are in support of that?
Mr. Chairman, members of the committee, Senator Perry is correct. VACA has discussed this bill, and we are in support.
Okay, VACA's in support.
Move to report.
This doesn't go to finance, does it? 'Cause we're actually reducing things, right?
Is there anybody opposed, I guess?
Yeah, is there anybody opposed to the bill? Doesn't look like it. Okay, it's been moved and seconded. Bill be reported. The clerk will open the roll.
Ayes 15, no zero.
Now we're down to the Survey bills. Just one bill.
Miracle.
Do I have a motion?
Well, this one actually is going to have some discussion, I think. So, the bill does three things, one of which I don't think is very controversial, and that's at the end, lines 145 through 153. Right now, when a criminal defendant appeals to the Court of Appeals, if they lose their appeal, the Court of Appeals is required to order the attorney's fees as costs in the case. And this would just make it discretionary so that the appellate bench can decide whether or not they want to order the attorney's fees for an indigent defendant to be paid, as costs. And that's what the first one does. I don't think that's that big of a deal, because right now it's mandatory. So for example, somebody can have a really good appeal, just lose it, but then they're ordered to pay the attorney's fees for it. So this just lets the appellate court decide whether or not to order the fees. The second one is on lines 88 through 90. And that just says if there's going to be an appeal bond in a case while it's pending in a civil case, that the court has to, the minimum amount of interest for the appeal bond is 2.5 years of interest. And that's because of the length the appeal's been taken instead of just 1 year. And the third one has to do with the length of appeals. So if you all know, we expanded the Court of Appeals a couple years ago. And at the time, the Court of Appeals was taking about 1 year to hear their cases. That's now turned into a lot longer. And when we adopted the Court of Appeals statute, one of the things the Court of Appeals asked for was the same authority that existed in federal courts for the appellate bench to dispense of a case without hearing oral argument, which that's what the federal rules currently provide. And myself and Senator Edwards were adamantly opposed to it at the time. And the Court of Appeals told us that if you don't give us that, it's going to result in these big backlogs, which is exactly what happened. And so the Court of Appeals, I've been talking with several of the judges there, and this is authority they really would like, and they think it would help them clear their dockets a lot faster. Apparently, in most appellate courts in the country that have this language, about 40% of cases end up going to oral argument. In the Fourth Circuit, however, it's only like 11%. And my conversation with the judges, they say they will not be like the Fourth Circuit. They'll be more like everybody else and go 40%. And which is why I put an enactment clause on here saying that this new authority to dispense of a case without oral argument will only exist until June 30th, 2027, which will force us to then look at what they've been doing to see if they've been, from my perspective, abusing that authority to not hear cases, and then we can decide whether or not to keep it. It'll sort of force us to look at it again. That's why the enactment clause is in there at the end under 2. So that's basically what the bill does. It does those 3 things. I think the first thing isn't that controversial. The second one just requires people to post a little bit larger of a bond. And the third one is really what the meat of the bill is about. And the way it's been described to me is what's causing all the backlogs in the Court of Appeals is that they have these argument panels, and they put so many cases per panel. And because they have to basically allow argument in every single appeal, whether it's meritorious or not, it's clogging up their argument dockets, which is then creating the backlog. And if they're able to dispose of cases without argument, they'll be able to fit more cases in for argument and still move their cases along faster. And like every other appellate court at the federal level. So that's what the bill does.
Are there any questions for Senator Surville?
Mr. Chairman.
Senator McDougal.
So I just want to make sure I understand. We took the jurisdiction of the Court of Appeals and expanded it, and we expanded the number of judges, and now the backlog went from 1 year to 2.5 years.
Yep.
And now
I'm not sure if it's 2.5 years, but it's a lot longer. I'll just say that. I'm not. And so there might be somebody here from the court can tell you how long the average case is, but it's longer and a lot longer.
But now, Mr. Chairman, just a question.
Senator McDougal.
But now we're going to say, and you used to have the right to an oral argument, and now we're going to say you might have a right to an oral argument. Some places that could be 40%, some places that could be 10%, but it might not be. That's not copacetic in my book. I mean, part of what the ability is to be able to argue your case. And if the parties agree they don't want to argue it, that's fine. Let them agree to it. But the fact that they don't have a right to argue it, that's a problem to me.
Yeah, we could also add another whole bunch more judges is another solution, but.
Or we could go back to the original jurisdiction the way it was.
I'm not going to do that. Okay.
Mr. Chair.
Senator Stewart and Senator Obenshain, I apologize.
So if I read this right, Senator Surville, if you're proficient in your documents, you're actually going to get cut out of oral argument.
Could be.
What if you're not very proficient and you think you are, and the judges look at that, you're going to get cut out of oral argument? I mean,
potentially.
Why would we do that? If we want to grant people an appeal in their cases, why wouldn't we give that individual the ability to go and argue before the court? I just can't see any reason why we would eliminate that. I guess that's what I'm struggling here with.
Well, this is the way it's done, and my understanding is every fellow appellate circuit in the state, I didn't do a measure to see how it works in other states, but I think in other states this is likely common practice as opposed to having an absolute right to oral argument. I mean, if you ask the Court of Appeals, what they'll tell you is the vast bulk of the appeals they get are like, habeas petitions from prisoners. It's like, the food isn't good, or, I want to relitigate my criminal case, whatever. They have a whole bunch of cases, not the kinds that you'd file, but a whole bunch of others that they're required to grant an oral argument in. And what's been described to me is they often get counsel sitting there waiting to have their appeals going and watch half the docket and then call up and say, why in the world are all those cases having to be argued? They sound like a complete waste of time.
I had one more question.
Senator Stewart has another question. Then Senator Obenshain has a question. Then there might be other questions or ideas.
Just as a result of what Senator Surville just said, then isn't there a better way to get at this? But you're giving them unfettered discretion to determine which ones they're going to summarily do away with without the benefit of oral argument. Why don't you set it out? That just bothers me. I think that is the hallmark of our judicial system, and I'm sorry, but I think judges ought to listen to the people that are petitioning whatever case it is, appeals or otherwise.
Okay, I think Senator Obenshain has a question.
I just feel like I'm in an alternate reality here. I'm really appreciate Senator Servell's conversion to the arguments that I think I made 3 years ago when we set about to expand jurisdiction, and I'm just perplexed by my colleagues down to my left who voted against expanding jurisdiction of the court. This is a real problem. A big problem. And when we talked about expanding jurisdiction of the court, we talked about delayed justice and the fact that people who expected a resolution of cases in a year or 2 years are now looking at 4 years in many instances if they wind up going through a fully briefed, fully argued Court of Appeals, petition for a rehearing, Supreme Court petition for rehearing before you get a resolution. And it is fostering a lot of inefficiencies. Everybody has, at some point in the process, an oral argument. If the Court of Appeals dispenses with oral argument, you still have an opportunity to petition the Supreme Court for appeal, and you get a panel hearing. Nobody is going to be deprived of a oral argument, but some of us, when we expanded the jurisdiction of the court, we predicted everybody's going to appeal everything. Because it's a matter of right, no matter how spurious or frivolous the grounds for the appeal are, and it is going to back up and jam up the court system. And you know what? That's what we've got, and that's what we've experienced. Other courts, we've given them some measure of discretion to make those judgments as to what cases would they be assisted with oral argument in. And I think that this does a good job of balancing the interests. It gives us a reenactment provision. If it's not working, come back in 27 and fail to reenact it. But I trust the judges we put on the Court of Appeals to exercise their judgment to decide whether they would benefit from argument.
Mr. Chairman.
Senator Servell, you can certainly respond.
Yeah, well, I just wanted to point out that what the bill did 3 years ago was not revolutionary. It actually brought Virginia into alignment with every other state in America. We were the only state in America where you had no right of appeal in every case. And that's what we did. The one thing we didn't do is put this kind of language in here so that the court would have the ability to cull through the cases that really needed oral argument versus the cases that could be disposed of without argument. And that's why we have this big logjam, which is what they were warning us about 3 years ago. I think there's also some people here to testify in support of the bill because, for example, it's been holding up a lot of development projects where somebody will just file a zoning appeal. But I can tell you, I have a case right now on appeal to the Court of Appeals. I've been waiting for 6 or 7 months for an opinion on a child support case. And since we litigated the case 2.5 years ago, we need to modify child support again now, but I can't because it's still stuck on appeal. And so it's affecting not just commercial cases, it's affecting family law, it's affecting some criminal cases, it's affecting almost everything, which is why the court is asking us for this. And if we don't pass this, we're going to be back here next year talking about expanding the court and adding a whole bunch of judges to it.
Let's hear what other people have to say, or you have questions.
If I could just ask a question, Mr.
Okay.
Chairman, and Senator Serval, I think the court has, like all courts, right, the ability to limit argument, right, and to put timelines and timeframes around how much argument they're willing to hear, right? We do it all the time in circuit court, right? We have motions and things like that. We say, hey, you got 20 minutes to make your point, counsel, right? Are they doing that? And I apologize, I don't know. Are they limited in some way, or is it's here's your day and have your day?
30 minutes, 15%.
And so even with 30 minutes, you're saying that they can't get through it?
Mm-hmm.
Okay, I thought about 20.
Mr. Chair.
Senator Obenshain.
The problem is the timeline established by the court. You've got the briefing schedule, then you've got the argument schedule, and then you have to wait for the opinion, and that winds up, you stick to that, and between finishing briefing and argument may be how long? 3 months, 4 months?
Between finishing briefing and argument, I've had it take 6 or 7 now
Briefing.
because of the delay.
Yeah.
Mr. Chairman?
Senator Perry, or Senator Carol Foy.
I was wondering if Senator Serval was deem it a friendly amendment to strike the lines 142 through 144. I think there's general consensus around every other aspect of the bill. I think it's just a lot of consternation regarding that area. Would the patron find it as a friendly amendment or no?
So you would have a period after reversed.
I'm sorry.
No, should strike that whole code section, 17.1403 from the bill is basically what you need to happen. But
Yeah.
why don't we take some testimony from some people first? I'm not really clear where the
Okay,
committee
any
is.
people that are in favor of this legislation, come forward. We did that.
Mr. Chair, members of the committee, Phil Abraham, representative Virginia Association for Commercial Real Estate. We thank Senator Serval for bringing this bill. I am not a litigator, but I've heard from a lot of the attorneys who are engaged in land use practice of growing concern over the delays in the appeals process that have resulted from the expansion of the Court of Appeals and for the lack of measures like Senator Serval suggests. Major economic development projects are now being delayed as long as 4 to 5 years with no bond requirements. All you need to do is file your pleadings, and you have these significant delays in major economic development projects. So we think this is a good first step. It has a sunset clause, see if it helps, and we'd also hope you would consider further steps next session to address this growing concern. Thank you.
Thank you, sir. Next.
Mr. Chairman, Andrew Clark with the Home Builders Association of Virginia would also echo Mr. Abraham's remarks from the housing industry's world. The cost pressures that are driving up rents and housing costs are both during the entitlement process, during the administrative process, and then to even push back against some of the appeals and challenges that come from local government approvals of the cases, and having to wait 4 to 5, 6 years to even contest that and have your voice heard. Whether you're going to get a good outcome or not, you get a lot of applicants who just decide to just pull the plug on a deal. And so while this is not my realm of experience by any means, this seems like a measure to at least provide economic development and housing development an opportunity to have their day in court. So I hope you support the bill. Thank you.
Thank you very much. We need to hear from the Supreme Court.
Alyssa Padden with the Office of the Executive Secretary. The court does support the inclusion of this language in 17.403, and I would just note that this would be consistent with the recommendation of Judicial Council when it studied the expansion of the Court of Appeals in 2020. It recommended to the General Assembly that it be done along with giving the Court of Appeals a discretion to dispense with oral argument when it deems that necessary.
Ms. Patton, is the 2.5-year delay accurate? Is that what we're up to?
The average is just under 450 days currently.
450 days, so that's about 15 months, 16 months, something like that.
Depends on your panel. It's an average.
Yeah.
Correct.
Okay.
What's the mean?
I don't have that on me, but the Court of Appeals has filed.
Senator Stewart's got a question.
No, I have a comment, but I can wait until the witness is finished.
Okay.
The Court of Appeals each year files a comprehensive report with the General Assembly detailing the expansion and the new workload and how cases are moving through the system. And so there's a lot of information available, a lot of data in that report. And they've committed to continuing that and to providing the General Assembly with the numbers of cases that are resolved without oral argument if you decide to make this change, so that you'll have an opportunity to evaluate it.
Okay, thank you. Senator Stewart now.
Mr. Chairman, I have to comment on this. It's very frustrating to me because these are exactly the things that we warned about when the jurisdiction of the court was expanded and everybody got an appeal of right. Everybody had an appeal prior to that expansion, may not have gotten the appeal. And now it's interesting to me, now you're suggesting that people should go through the motions and file their appeal, but we're just going to summarily dismiss those and you don't get an oral argument. We may be worse off than we were before the court was expanded if you do this. And it is interesting to me, I feel like I'm in an alternate reality too, because Scott, you and I are like on the opposite sides of this spectrum, and we're arguing for the other side that normally we would be arguing for. But I hope we don't do this. I think it's just wrong to limit people's oral argument before any court whatsoever. It is the premise of our judicial system, and the judges need to listen to what the litigants have to say in order to render a decision.
I thought this guy was sick.
He is. What?
Mr. Chairman, I would just note that we didn't have a right of appeal before. We had a right to go to the Supreme Court, beg for appeal, and the Supreme Court only granted appeal in about 1 to 3% of cases or something like that. So there wasn't a really effective right of appeal on civil cases, aside from divorces and workers' comp. And that was what the original expansion was designed to address, among other things. But, Mr. Chairman, it strikes me that I'm not really clear where the votes are on this and whether there might even be potentially middle ground with some folks. I just think we ought to take this by for a week or two or something like that.
Does anybody have any objection to that? Okay. The bill will go by.
No, that's not my committee. That's somebody else's committee. All right, huh?
Oh, that's right. We got all day on Friday.
Yeah, we'll do it Monday, maybe. Okay, I think that's it for the docket, Mr. Chairman.
Okay, we'll rise.
Yeah.
Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia.